Good afternoon, ethics students. Orozco here, and I'm going to be talking to you about abortion. And that's the second ethical kind of topic that we're going to talk about in this third section of our class. The first section of our class, when we were still face to face, was ethical kind of theory in terms of the three parts of the human act and things like natural law and Aristotle kind of coming up with the basic framework of an ethical theory that kind of pushes back against relativism. So remember, relativism is the typical, almost universal way of looking at ethics, which says that ethics is basically a matter of personal opinion or cultural opinion. And Aristotle was kind of like the first person that I ever encountered as a philosophy professor. He was the only one that I ever kind of really saw that he promoted a philosophy of kind of like a natural law theory that would allow a pushback against ethical relativism, because human nature is kind of a natural fact, and human nature is something that has to be protected because it belongs to everybody equally. So that was Aristotle's position. That's what we did in the first part of the class. The second part of the class, and we just took a test on the second part of the class, was different ethical theorists. And we looked at Aristotle a little bit more deeply, and then we went into Buddhism, divine command theory. We talked about Jeremy Bentham and Immanuel Kant, and you took a test on that. Now in this third section of the class, we're just kind of looking at different, if you want, like case studies in ethics. So we looked at sugar babies. That's something that you guys read on your own. I didn't really have a video with it. I think I just kind of like posted something to you on the announcement page. And then, so today is a second topic in the third section of the class, which is dealing with abortion. And in the book, there is a article that's pro-choice, and pro-choice basically means, in defense of a woman's right to choose to end the pregnancy. That's pro-choice. The woman should have the choice, pro-choice. And there's an article in the booklet by Lisa Fleishman, and then there's an article that you'll be reading for Tuesday, April 14th, which deals with a pro-life argument. So I'm going to be talking to you a little bit about the basic issue of abortion, because, as you know, it's one of the most divisive ethical issues in the world, not only in the United States, but in all kinds of other countries. Latin American countries, which are strongly Catholic, that their whole issue about abortion laws have started to take flight there, even in Mexico, Costa Rica, in many parts of Latin America, in Spain, which is a traditionally Catholic country, France, many other countries in the world have been discussing abortion over the last couple of decades. And so it's an issue that's not going to go away. And abortion, it's a really contentious issue because it has religious principles involved and also personal right issues involved. So the state, on one hand, defending personal rights, is in conflict with universal religious teachings. And so it's a huge conflict, and it makes or breaks presidential elections or state elections, because most people just want to find out where a politician stands on their abortion position. So that can make, millions of voters throughout the United States decide whether they want to vote for you or not. So it's a huge issue. And in the last couple of years under the Trump administration, there's more and more rollback going against abortion laws. So when did it all start? Well, abortion in this country became legal in 1973 with something called the Roe versus Wade Supreme Court decision. That was 1973. Roe is the fictional name. It's not a real name. You know how in men, when they don't know the identity of a man, or they don't want to release the identity, they call a man John Doe, D-O-E, John Doe, like John anybody. Well, in order to defend the woman who brought forth this case where she wanted to have an abortion in Dallas, Texas, they called her Jane Roe. So instead of John Doe, they called her Jane Roe, R-O-E, Jane Roe. And basically, it was a Texas court that decided that it was going to uphold this woman whose real name was Nora Leah McCorvey. It's kind of a three name. She has three parts to her name. Norma Leah McCorvey. And she was a single woman. She had had a child already, but because she had problems in her life, a lot of problems, domestic problems in her life, she could not keep her first child and gave up her child to her mother. I'm not sure if it was a legal adoption, but she gave her first child up so that her mother could take care of it. Then she had a second child, and she also was in a difficult position. So Norma Leah McCorvey gave her second child up for adoption. She kept the baby, had the baby, but then gave it up for adoption. So that was the second child. Now she was pregnant for the third time, and she decided that, there was just no other place to go with this child. She had already given the first one up to her mother, gave the second one up for adoption. Now she wanted to find a defense or somebody or some legal mechanism so that the state of Texas would allow her to end this pregnancy. In 1973, I don't want you to think that this was the first time in the United States that women or many pro-choice people had been arguing or looking for a way to provide safe abortion. I don't want you to think that 1973 appeared and all of a sudden there was this abortion case. I mean, it had been going on since the 1960s probably, where women were looking for a safe, legal way to terminate their pregnancy or to have an abortion. So 1973, it just took that long before one state in Texas agreed, and then of course that started a whole, kind of like the ball rolling or the momentum starting, so that it became not only a Texas law, but then it soon became a national law. And so now that's the law of the land, Roe versus Wade, and it gives women the right to an abortion. Now, the Supreme Court justices, when this case made it to the Supreme Court, first it was in Texas court, but then when it made it to the Supreme Court, they basically decided that a woman could have a right to an abortion based on the 14th Amendment. And the 14th Amendment was something that came out in 1868. So this goes back, a century. And in 1868, after the Civil War, the Supreme Court, I'm not sure exactly the mechanism, but I think, yes, the Supreme Court basically allowed for the 14th Amendment, which is basically the right for people to be defended for their pursuit of life, liberty, and happiness. So slaves, right after the Civil War ended in 1865, but there wasn't any legislation to really protect these newly emancipated slaves. There was no legal protection. So in 1868, the 14th Amendment was created so that these new group of people, slaves, would be guaranteed the right of life, liberty, and the pursuit of happiness. It was a protection of their rights. And so in 1973, the Supreme Court went back to the 14th Amendment and basically said that people should be guaranteed the right to the pursuit of life, liberty, and happiness. And if women who were pregnant and did not want to keep the pregnant, if they were denied the right to end their pregnancy, that would in effect deny their right to life, liberty, and happiness. In other words, if you're poor and if you're pregnant or for whatever reason, you don't want to keep your child for economic reasons, for financial reasons, because of boyfriend or domestic partner or husband reasons, for whatever the reasons, if a woman would be severely impeded in her rights for her pursuit of happiness, then keeping the child would be depriving her of her rights to the pursuit of life, liberty, and happiness. And so basically the Supreme Court judges basically said that an unwanted pregnancy would limit a woman's right to protect, the life, liberty, and happiness. And you can see that if a woman is not in a position to be able to have a child for whatever reason, you can see that not being able to go to school or being faced with all kinds of other economic hardships or living situation, you could see how an unwanted pregnancy would be a huge impact on a woman. So that was the motivation or the justification that the Supreme Court in 1973 allowed for the right for women to have an abortion. So very contentious issue. And so you have in the booklet, you'll have a pro-choice position from Lisa Fleishman and then a pro-life position from John Noonan. So let's talk about the first article that hopefully you read last week by Lisa Fleishman. And my understanding of it, I hope you guys answered some of the questions, otherwise you're kind of in the dark in terms of what I'm talking about. But in the Linda Fleishman article, she accepts that life begins at conception. So that when you have the sperm that fertilizes the ovum, that is the moment that actually life begins. She's realistic. She's not going to hide behind the fact, well, we don't know when life really begins. Does it begin 8 weeks later when there's a little fetal heartbeat, or when we can measure some little electrical activity in the tiny fetal brain? She says, let's not even go into that. Let's just accept that life begins at conception. It's exactly the moment when the sperm and the ovum, exchange genetic material. That's when life begins. She understands that life probably begins at conception, but her argument is that as a society, we do tolerate the taking of life. And then she mentions a couple of instances in which society, American society, permits the taking of life. We do that in war. So when we authorize a human being in the military to put on a uniform and in defense of the country or principles that the country wants to defend, when it sends a person off to war and is enabled to kill another human being, that is the taking of life. We also do that in the death penalty. We also do that sometimes in indirect ways. For instance, when our country or a government, a local government, doesn't fund programs for the homeless, and let's say it's a bitterly cold winter and there's no program for the homeless, and certain homeless people are going to die, like during this COVID epidemic. There's certain people where we're not directly killing them, but by not providing services for them, in a sense, we're allowing them to die. So Lisa Fleishman is saying, look, let's accept that life begins at conception and that it is a human life. But she's saying we need to be realistic about the fact that society already allows for the certain taking of life. And in the case of a woman who wants to end her pregnancy, this is simply one other avenue in which a human being is deciding to take life. That's a complicated argument because, yes, society does take life, but it has to be kind of like authorized under certain criteria. For instance, they send you to war, but supposedly there's just reasons for you to be taking human life. There's some kind of geopolitical issues or a threat or an invasion or something in which the government is authorizing you. So there's severe and serious reasons. In the case of the death penalty, there's severe reasons as to why the state can now execute a person. Lisa Fleishman is saying a woman, and sometimes in a desperate situation, is finding herself also with a serious motivation to end human life. So does that rationale hold up? Is that a good enough reason? Because notice when they send you off to war, there's a whole big judgment of the state and government and the president and the Senate and the Congress that are part of that decision to send a young person off to fight in a war. It's not an individual decision. And even when the state executes somebody in capital punishment, that's been a process of legislation. But a woman who has a right to privacy, um, guaranteed by the 14th Amendment. The 14th Amendment, along with life, liberty, and happiness, guarantees you the right to privacy in the pursuit of life, liberty, and happiness. That's also one of those kind of like corollaries, a little side part of the 14th Amendment, that you have a right to privacy in your pursuit of life, liberty, and happiness. I probably should mention really quickly that a couple of years before Roe versus Wade in 1973, the justices in another Supreme Court case, allowed a person to be able to get contraception privately because that was his pursuit of life, liberty, and happiness. Because there were some states that didn't even want you to allow you to buy contraception. And so the state or the Supreme Court, a couple of years before Roe versus Wade, had given a person under the right of privacy, the right of that person's privacy to pursue life, liberty, and happiness by being able to buy contraception. So Roe versus Wade was another way in which a woman, in pursuing her life, liberty, and happiness, could have the right to privacy in pursuing the life, liberty, and happiness. And that's basically how they justified the right to abortion, that it was her privacy to be able to pursue her life, liberty, and happiness. And so, but in the cases in which going back to the Lisa Fleishman article, but in the cases in which we do allow killing, there's a whole mechanism, there's legislation that's involved to put a person in war situation. There's a lot of laws and mechanisms that are involved in capital punishment. But the right to an abortion kind of gives a woman almost a decision over life and death in which she doesn't really have to consult anybody. It's a privacy matter in much the same way as that a person a few years earlier in a Supreme Court case had the right to privacy in buying contraception. So the court kind of protected that person's right to privacy. So anyway, but Lisa Fleishman is saying, so it's a sticky issue, but Lisa Fleishman is saying, let's just be honest about it. Society already takes life. This might be a case when a woman decides to end her pregnancy. This is also one of those cases in which a life is taken. Remember, because it is human life. She's admitting that, and she's a feminist. She is a pro-choice person, but she says it's true. Life starts at conception. It starts at the very beginning of the sperm and the ovum meeting. So she's not arguing that, but what she's saying is just kind of taking a cold, hard look at the fact is that society already allows killing to take place, and a woman in a certain time and place is exercising her right to end life. The stickiness of that situation is that, yes, but she has almost life and almost godlike decision making where she doesn't have to go to any kind of appeal. She doesn't have to debate it in Congress. She doesn't have to, it's just her personal right. That's what makes it sticky. Nevertheless, Lisa Fleishman says we end up taking life, and a woman is basically has that power to end her pregnancy, and it's legal. So, that's her argument. It's kind of like, just let's be honest about it. John Noonan was a federal judge and kind of conservative, very Catholic. I met him, by the way, at Cal Berkeley one time. Very tall, statuesque, wasp of a man, this great, ethical man. And he basically wrote this article, An Almost Absolute Value in History. That's the name of his article. And an almost absolute value in human history. And he has several pro-choice, pro-life arguments. And basically it's that he kind of goes like about for four or five reasons as to why the pro-choice position is actually illogical. The first argument would be like viability. viability means, or pro-choice people say, well, since the embryo cannot really survive, not embryo, but since the fetus cannot really survive on its own, it doesn't really have an independent, autonomous life. So a mother can end that pregnancy because the fetus doesn't have a separate life. It's not really a person because it's totally dependent within the life of the mother. And but John Noonan saying that viability argument doesn't really hold water because modern science nowadays can almost take, I mean, even an embryo that's fertilized in vitro, like in a dish, it almost can preserve, theoretically, a human life right now. So that thing about viability, that it gives a woman has the right to end a pregnancy because the fetus is not viable. It doesn't have a separate identity apart from the mother. And John Noonan is saying medical science today is practically ensuring that almost right from the beginning of conception, that technologically we're going to be soon able to have a fetus develop even outside of the mother. So that argument doesn't really hold water anymore. He's got a couple of other arguments. I'm going to kind of like summarize them really quickly so that we don't make this a very long video. But there's another argument in which he says, well, a fetus doesn't really have its own memory. What makes a human being? What makes a human being? Memories, experiences, the ability to have speech, the ability to function. Those are all things that make a human being, a human person. John Noonan, and since a fetus doesn't have memories, it doesn't have speech, it doesn't have like a history, it doesn't have autonomous functions, it doesn't really have the status of personhood. So why should it have this right to protection when it doesn't even have the status of personhood yet? John Noonan will look at that and say, well, there's other people who have lost their memory as adults, and yet they're still persons. There's people that have Alzheimer's and can't really speak anymore, or they're in a rest home, or they're in a coma. They can't really form memories anymore. They're kind of a vegetable, but they're still human. So if we're going to allow that a human being as an adult can lose its memory, can lose its speech, can lose its ability to function, and yet is still recognized as a full human being, John Noonan is asking, why shouldn't we extend those same rights to a fetus? Because a fetus can't do that either, but neither can some adults. Adults are protected. Why shouldn't we protect a fetus who doesn't have those functions yet? So there's an argument in favor of pro-life. In other words, that this is a life that needs to be protected because we protect human beings who are kind of defenseless. And that's where John Noonan's kind of argument is. He's also saying that if a human, like once the sperm and the ovum meet, there is a very, very high likelihood that all the genetic material is going to be transferred. The male sperm cell and the female egg is going to translate all their human experiences. And it's not going to turn into a turtle. It's not going to turn into an alligator. It's not going to turn into a bird. It's going to be specifically human. And so I think what John Noonan is getting at there is that nature is intending from the very beginning for a human life to take place. And you can't really say that a human being starts at, let's say, the 8th week, because or when it has little fingers, or when it has a heart, or when it has a head, very recognizable humans, because 2 weeks before that, it was still human. And 2 weeks before that, it was human, even though it didn't look like a human. It looked more like a tadpole, but that was still human life. It was the spectrum of human life, not just at the 9-month period, but it was human at the 8th-month period. It was human at the 7-month period. It was human at the 6th-month period. It was human at the 5-month period. Indeed, it was human, although not looking like a human, all during those 9 months, because it wasn't going to turn into something else. It was going to be a human being genetically. So he's saying, that a human being needs to be protected, not only in the ninth month or in the day after a child is born, but the day before it was born and all the days that it was in the womb, it needs to be protected because it was a human being. So you can see, man, that this is a very complicated issue, and I don't know where you guys stand on this issue. It's very complicated. There's a lot of rollback on some of the abortion rights that we have right now. For instance, I'm not sure if it was in Carolina or in one of the eastern, southern eastern parts of the country, in which women who were coming in to have an abortion were required, or I'm not sure if the legislation went through, but they were required before they went ahead with the abortion to listen to the fetal heartbeat or to see a picture on the sonogram. So, in other words, they didn't want a woman to be able to go in and have an abortion until they had had the opportunity to see the image of the child, the fetus, in as a sonogram picture, or to listen to its heartbeat. Well, pro-choice defenders were saying that that was an invasion of a woman's privacy, and it was like guilt and manipulation, and that, a woman shouldn't be subjected to something like that. And so we're getting more and more pushback um, from pro-life people. And of course, the Supreme Court is very conservative now. It's got five judges of the nine, so 5-4. Five judges are pretty conservative and pro-life advocates. And so we're going to see where the abortion issue goes in the next couple of years. So anyway, that's a very brief report on a very complicated issue. And so listen to this, read the two articles, answer the questions that I have in the booklet regarding the Lisa Fleishman article, and then answer the questions regarding the John Noonan article. And then I'm going to post a discussion board opportunity for you to kind of weigh in on your kind of philosophy about what you think about the abortion issue. Orozco out.